Well, good afternoon, everyone, and welcome to this webinar hosted here at UTS on the changing legal needs of people living with a blood-borne virus, looking particularly at perspectives from lawyers and clinicians. We'll just give everyone a couple more minutes while they file in, and then I'll begin introducing our speakers for today. Well, thanks everyone. My name is Dr. David Carter, and I'm a lawyer and legal academic joining you from the Faculty of Law at the University of Technology in Sydney. And I want to just welcome you to today's webinar. We really appreciate you all joining us today. By way of introduction, I'm a legal academic and my expertise focuses on medical health law, with a particular focus on how law is a factor in the cause, distribution and prevention of communicable conditions and health. In the interest of full disclosure, I'm a member of ASHM and the HIV/AIDS Legal Centre, who are both partners in this research. I also sit on the board of the HIV/AIDS Legal Centre. Our research team for the presentation today has received funding from UTS, where I work, and the NHMRC supports my work on this project as well through an early career fellowship. So I would like to first begin by acknowledging the Gadigal people of the Eora Nation, upon whose ancestral lands our city campus now stands. I would like to pay respect to the elders, both past and present, acknowledging them as the traditional custodians of knowledge for this land. Given that we are joining this webinar from many different places, I would also like to acknowledge the traditional custodians of the various ancestral lands from which our other attendees join us today, and pay respects to those elders past and present. I would like to begin first by just introducing our speakers for this afternoon. I'll have them just turn their cameras on for a brief moment to put a face to a name. First up, and in order of how we will be engaging with them today, is Rhys Evans, who will be speaking first. Rhys is the Policy Projects and Law Reform Solicitor at the HIV/AIDS Legal Centre, often referred to as HALC. Benjamin Riley is the second speaker, who is the Policy and Public Affairs Manager at the Australasian Society for HIV, Viral Hepatitis and Sexual Health Medicine, thankfully also known as ASHM, much easier to say. Following Rhys and Ben, we will be joined by Carrie Fowley and Erin Kogel. Carrie is the CEO of Hepatitis Australia, and Erin is the Executive Director of the National Association of People with HIV Australia, known as NAPWA. They will be joining me to digest some of the material presented today and to start to think about some of the policy implications of this work. So thank you all for joining me, and we'll be speaking with them throughout. But I'll now just take the screen back over again and share a few practical matters so that we can begin today's presentation. First things first, we encourage you to ask questions today. Some of you who may or may not have been in a Zoom webinar before realise that that's done through this Q&A function. There's a couple of steps here on this slide. Part of today is we won't be able to, of course, answer everyone's questions necessarily, but we do commit to looping back to you via email if there's something that we feel we can answer later on. So please feel free to ask those at any time, and we'll get through what we can, but we will loop back to you, we promise. Something that's important, given the topic of today's discussion, is referral and support for people with legal needs. Here's some information about the HIV/AIDS Legal Centre and the support it provides different clients. You can contact HALC for information, advice, referral and legal services. They will do their best to help if people are in New South Wales, and indeed provide information and referral if they are not. A new resource I want to highlight today as well has recently been released, the Positive Migration Guide. This is a guide for those living with HIV, their family and loved ones who are thinking of migrating to Australia or who are in the process This guide has been completely rewritten by the excellent Alex Strategos, who's the principal solicitor of the HIVs Legal Centre, and I. We encourage you to read it. We encourage you to use it by sharing a link to the HALC website for those who might benefit. I should say too, it's useful also for people not just living with HIV, but also anyone with a BVV generally, other disabilities or indeed conditions that might mean migrating to Australia becomes difficult under migration law. And so we think that's a really useful resource. Today, at some point, we will pop out a poll to you as well if you would like to opt into information and to receive information, I should say, on future webinars, research, education and events. That'll pop up at some point towards the end. Please just opt in and we'll grab your email address through that process and be able to email you with those resources. I want to just begin the webinar though by thanking people. We often leave it to the end, but I think it's nice to put it right up front. And first and foremost, I want to thank those people living with BVVs, as well as the clients, past and present at the HIV/AIDS Legal Centre, without whom this research would not be possible. In particular, I want to thank the staff, the volunteers and community members associated with Positive Life New South Wales, Hepatitis New South Wales, Queensland Positive People, QPP, and Hepatitis Queensland. These organisations and the people that gather around them worked alongside my team at UTS, alongside ASHM and HALC, to shape this research and to guide how we went about it. Their insights, their expertise was entirely decisive, and it continues to shape and direct the work we are currently doing. I personally couldn't thank you more, and I hope that we've done you justice in this work. And finally, just a thank you to Katrina Matheson as part of my team here at UTS for arranging the webinar behind the scenes. We couldn't do anything without you, Katrina. Thank you. Thank you so much. Well, so before I hand over to Rhys Evans, just a tiny little bit about this research. I think it's important to give some context. What we're presenting today is a very early look at a much larger project. There'll be more news to come in the future about it. In this larger piece of work, what we're doing is trying to understand and to respond to what we term the legal needs of people living with a BVV in Australia. What we aim to do in this early work was to start the process essentially of triangulating a few different sources of information about what legal needs are today and what they might have been in the past. We were particularly interested in this to understand particularly change across time or continuity across time. So what might be new, what might be different, and what remains the same after many years. We started this process by examining the experience of clinicians and of lawyers. This is what we're going to present today. We did this because we wanted to kind of, get our eye in to the topic. All of us work in this space, and so come to it with a lot of preconceived ideas. And we wanted to be sure that there was a good story to tell and that it justified the next step, which is us starting conversations directly with those with lived experience who are busy living their lives and who are facing and resolving legal needs and issues as part of that life. Indeed, we're now engaged in that interview process. We're interviewing people living with a BVV, and we're starting that process of spending deep and sustained time with them to understand the impact of law and legal needs from the perspective of their lived experience. As I mentioned, the project that we're reporting on today was a small starter for us. It was funded by UTS, thankfully, through a cross-faculty grant. And it's meant that we've been able to pilot a range of ways of trying to understand the landscape of legal needs today. The team behind this work was led by me at UTS, but it was a true partnership of a much larger group of wonderful colleagues and organisations who I want to thank. We have a new set of colleagues and organisations too joining us on the next stage of this research. But for the work we're presenting today, primarily it was UTS Faculty of Law, the HIVs Legal Centre and ASHM as our partners. And then from those organisations, very pleased to work with and say thanks to Ben Riley and Rhys Evans who are presenting today, as well as Alex Strategos and the solicitors of HALC. The academics on the team who are watching, I know, and we're happy and pleased to see our industry partners presenting our work today, is made up of Dr. Anthea Vogel from UTS Law, who's a migration and administrative law expert, Professor Joe Travaglia, who works across health services and multicultural health research around vulnerability, precarity and risk, Professor James Brown, who's the ABS Professor of Official Statistics and a fantastic social statistician, and Dr. Hamish Robertson, who's a health and medical geographer, who we're pleased to have join us today. So without further ado, I'm going to hand over to Ben Riley from Asham, to Rhys Evans from HALC to begin his presentation today. Again, please ask questions as you do throughout the presentation in that Q&A function, and we'll gather them up towards the end and ask them in a big lump. So Rhys, if I could ask you to put on your video and begin your presentation. Thank you very much.
Am I unmuted now? Yes, excellent. Okay, great. And let's start that. Okay, great. Hi, everybody. Thank you for having me, David. Thank you for the introduction. And I'm zooming in today from Gadigal land. I'll be sharing with you an analysis of 30 years of data that we've pulled from the administrative records and databases of the HIV/AIDS Legal Centre. And just before I start, I just want to echo what David has said and just start by thanking the people living with HIV and viral hepatitis and all of our clients, past and present, who without this research would not have been possible. So thank you very much. So just as a brief background of the HIV/AIDS Legal Centre, or as we refer to it as HALC, we're the only full-time specialist accredited community legal centre of its kind in Australia. We were established in 1992 and we act for people with HIV or viral hepatitis related legal issues across critically affected populations. So those populations being identified as priority populations in the Australian National HIV Strategy. HALC primarily provides its services to clients in New South Wales. That's where most of our funding is for. But we also do receive additional funding from projects and partnerships where we can provide services to clients outside of those jurisdictions, outside of that jurisdiction. Now, the data that we extracted for this paper is from HALC's administrative database, which is known as the Community Legal Assistance Service System class. All community legal centres use this to record their legal service delivery across their centres. And just a couple of things to note when I'm presenting this data. There's just a couple of caveats on data quality and completeness, but generally over time, the accuracy and amount of data that was available from the database improved. It's also important to note that while HALC does assist in both HIV and hepatitis related legal matters, the vast majority of our matters are HIV related matters, as that's what we were originally established to assist with, and then have expanded that work due to the similarities of experience and kind of the legal issues that are faced by people living with hepatitis. All right, so let's turn to the data. So we can see that the number of unique clients has increased annually over the 30 years. HALC provides legal services to approximately 40% of all those living with HIV across New South Wales over a 5-year period. And as expected, in the increase in the number of new clients is obviously translated into an increased number of legal services provided. So between 2010 and 2019, HALC provided an average of about 1,000 discrete services per annum. This peaked in 2017 with 1,300 services delivered. And these services include referrals, information, legal advice, legal tasks, and representation services. I'd also just like to note there was just a dip there in 2020. That's because we pulled the data about, I think we were nearing the end of 2020 and decided only to pull from half of that year. So that's why there is that sudden drop. But because we thought the accuracy was important in that year for demographic data, we still pulled from there. So looking at the demographics, so when we analyze the data in the context of the epidemiology of HIV in Australia, we can actually see there are divergences between that data and HALC's clients, so particularly in areas of age, gender, and sexuality. If we look at the complete data set, so from 1922 to 2020, we can see that most clients were between the ages of 35 to 49 years old, And over the entire period, those who recorded their sexuality, 20% identified as homosexual. But if we focus on the most recent data, so that's the data between 2010 and 2020, and the reason we're doing this is because it is when the data quality was at its highest. We can see that approximately 80% of all clients were under the age of 50. This age profile varies from the age profile of the HIV epidemic in Australia, where it's now estimated that approximately 40% of all people living with HIV are now 50 years or older, and this proportion is steadily increasing. We can see as well, if we look at the self-reported data from 2015 to 2020, it shows that 44% of clients identified as homosexual and 31% identified as heterosexual. Again, this points to a potential variance in the sexuality profile of the HIV epidemic in Australia. So in Australia, HIV transmission has historically occurred primarily between men who identify as homosexual. And I should note that HALC does not collect data on the context in which transmission occurs, but only on sexuality. And while these concepts do not measure the same characteristics, it is still interesting to note that the recent estimate shows that 23% of transmission cases are attributed to heterosexual sex, whereas 31% of HALC clients identified as heterosexual. We also know that HALC has an overrepresentation of female identifying clients when compared to the epidemiological data. So the number of female identifying clients seeking HALC services has on average been approximately 20%. Again, in contrast, we see that it's estimated approximately only 10% of people living with HIV identify as female. Finally, and what might be one possible reasoning for these divergences is that increasingly people accessing legal services at HALC were born overseas. So between 2011 and 2020, on average, only 27% of clients were born in Australia. This demographic, especially female identifying clients living with HIV, potentially have faced more complex legal issues that could have been compounded by forms of domestic and family violence, and also just the unique pressures of living with HIV as a female. And the demographic of migrants as well has experienced legalized discrimination because of their migration status, which could significantly burden them with further issues with employment, housing, and access to healthcare. And that's something I will touch on in a second. So the rise in people being born overseas has translated into an exponential increase in immigration-related legal assistance, which you can see there in pink. The growth in immigration work can be attributed potentially to the change in the health criteria policy by the Australian government in 2009 and 2010, which did increase the options available for people living with HIV to obtain a visa. Other areas of law, as you can see there, such as wills and estates in light blue, discrimination in green, and consumer complaints, these have all been relatively consistent over time. Now, that was a very brief overview of the data, but there is just a couple of important points that I want to draw out. Firstly, the demographic of people living with HIV seeking legal services indicates quite clear divergence with the epidemiology of HIV in Australia. So as I noted, this could be attributed to the change in immigration policies, with a larger number of people being born overseas seeking assistance from HALC. And what we need to consider is how these often underserviced demographics in Australia's response to HIV, including female identifying clients, migrants, and heterosexual identifying people, are interacting with our justice system due to their HIV status, and then what impact this may have on their access to treatment and support. I think it's also important to recognize that there are areas of law that are often at the forefront of our discussions in this area, such as criminalization of transmission, and that's not really reflected in this data set. And this is not to say that these issues are not vitally important to be addressing. And a lot of HALC's law reform work is focused in that area. But what this data is showing that areas such as immigration, discrimination, and disclosure issues are really the main areas that are coming up more frequently, and access to support services and intervention are really important, particularly in those areas. I just want to take for a second an example of a migrant who potentially is currently on a student visa, who has recently been diagnosed with HIV, and just explain some of the legal issues that they could potentially face due to this one issue. So if they're trying to obtain permanent residency in Australia, upon diagnosis, they would be informed, if they're seeking advice, that there are quite limited options available to them when trying to obtain permanent residency. They're also being informed that their HIV status will be shared with a government agency, so with the Department of Home Affairs when they apply for the visa. And they're also being informed that this is going to be a very lengthy process. I mean, somebody who applies for permanent residency at that initial stage, so at the department stage, is looking at about a 2 to 3 year wait potentially to get a result. And then if they're unsuccessful at that initial stage, again, we're looking at another 2 to 3 years at the Administrative Appeals Tribunal. And if unsuccessful there, then we have appeals to courts. So even more time spent there. And throughout this time, we need to consider the context that they're in. So, for example, while they're on their student visa, they might not have had work rights, meaning that they might not have had access to Medicare, depending on what country they've come from. And also because of their migration status, may have struggled to actually find consistent employment. And then this is not even taking into consideration other issues that may emerge, for example, disclosing to an employer about their HIV status, any family law issues, housing issues, and things like that. So what I'm trying to highlight here is that the clearly identifiable HIV-related legal issue, being the permanent residency issue, it can actually create and exacerbate further legal issues. And this is why it's so important that people seek out support and advice as early as possible, particularly for that process. And it's also important that these services understand not only the challenges that the clients are facing immediately with the actual permanent residency process, but what the next 5 years actually look like potentially for the client, and what issues they may face and how to mitigate those types of issues. I just want to finish by talking to what the data does not show as well. And by that, I mean these kind of other legal issues. So due to the limitation in the class system, our reporting system, it's difficult to break down some of the legal issues clearly. And instead, we need to rely on HALC's experiences and our law reform priorities to interpret them. So I'm not going to go into every area, such as housing, credit and debt, and family law. There's just a couple of notable areas. So firstly, disclosure in employment settings. Employers that undertake medical checks often ask very broad questions, such as, do you have any health conditions, or are you on any medication? And we quite frequently receive inquiries about this issue and how clients should respond, and our advice to how they should be responding does vary on a range of circumstances, such as what exactly is the question asking, what type of job are they applying for, and as well as what is it they're actually signing? Is it a statutory declaration or something like that? The next area is that we have a number of discrimination matters involving insurers. So we have people who've applied for income protection or total and permanent disability insurance, and they've been refused. And this is, again, a form of legalized discrimination in all jurisdictions in Australia, where insurers can discriminate as long as they're relying on reasonable actuarial and statistical data. We're currently challenging that because of the approach that insurers are taking in refusing this insurance. Sometimes it's at the initial disclosure, sometimes they ask for more medical information and then they will refuse, and then sometimes they will just charge so high premiums for the insurance. So we don't understand why there is this large discrepancy. We're trying to get a better understanding as to why different insurers take these different approaches. And then finally, we also receive a lot of inquiries about unwanted disclosure, particularly by family members, friends, sexual partners, or other people they may have disclosed to, such as employers and co-workers. And unfortunately, there are very limited legal remedies to this issue, and our ability to assist as a legal centre is quite limited. And again, depends on the context. For example, is there any domestic violence involved? What's the nature of the relationship? How did the person actually find out about the status? Where did this information come from? So again, depending on those circumstances, there may be different remedies, but generally there aren't too many. So I'd just like to close by saying that this data that we have obtained through this research and our continued research can and really should help inform our policy and practice changes in Australia. HALC has already drawn upon this analysis in planning our services and in our law reform agenda. The data demonstrates just how essential it is to recognise not only the changing landscape of medical treatment, but also the role of enabling legal and policy environment to support effective prevention and treatment. So yeah, thank you very much, everybody. I'll hand now back to David.
Thank you very much, Reese. That was fantastic. A lot of facts and figures, and thank you for people who are sending through questions on the Q&A. Please do just click that Q&A button at the bottom there, and we'll get to those questions in the next little while. Now over to Benjamin Riley from ASHM, who'll be presenting information from the clinician point of view, some recent work we've done asking the STI and BBV workforce about their experiences of legal needs of patients, clients, and people they work with. Thank you, Ben.
Thanks, David. I will share my screen. Okay, is that all looking okay?
Thank you. Yes, Ben.
Great. Thank you, David. I would also like to acknowledge that I'm presenting today from Gadigal land. I'd like to thank everyone involved in this research, including all of the research partners and everyone who participated. I'd also like to acknowledge the critical role of people living with and affected by BBVs who have participated in research over many decades. I imagine most of you are aware of ASHM, but if you're not, we're a national peak body representing the health workforce in HIV, viral hepatitis, and sexual health. So today I'll be presenting the results of a survey of the Australian STI and BBV workforce about their views and experiences of the legal needs that their patients and clients face. Given how little data we have on the legal needs of people living with BBVs, this is really about getting a very initial picture of both the legal needs of those groups and also the needs of the workforce in supporting their patients and clients in relation to those needs. As we'll see, the STI and BBV workforce are acutely aware of and engaged with the legal needs of their patients and clients. They report that legal needs generate significant impacts on the health and well-being of their patients and clients, and that they are already actively attempting to assist and support their patients and clients with their legal needs, despite the workforce's own need for further education and practical support to offer this support to their patients and clients. So a bit of background, some of which Reese has already spoken about. Australia has long acknowledged law and the legal context as a key enabler of effective responses to HIV and other BBVs or STIs. As far back as 1989, federal, state and territory governments have, in close consultation with affected communities, demonstrated global leadership in centering the need for an enabling legal environment to respond effectively and justly to the HIV epidemic. So notably, law and the need for an enabling legal environment have been features of successive national strategies for HIV and viral hepatitis ever since the first Australian national strategy for HIV in 1989. So despite the fact that there is an increasing recognition of the link between unmet legal needs and health in Australia, as well as this sustained focus in the national strategies and elsewhere on law and enabling legal environments at the policy level, we really don't know very much about what those legal needs look like. We don't know how they impact on the health of people affected by BVVs and STIs, or on the provision of health services to those populations. So given this knowledge gap, we sought the perspectives of the Australian STI and BVV clinical workforce on the legal needs facing their own clients and patients. We wanted to know how the workforce understands the effect of those legal needs on individual and public health, as well as the workforce's ability to respond to those needs. So who did we talk to? So we developed a survey targeting clinicians and support workers who provided patient or client services in Australia relating to BVVs or STIs, and we received 32 responses to that survey. 41% were medical practitioners, 19% registered nurses. We had a counsellor, a social worker, and 34% responded as other. That included LGBTIQ health promotion workers, pharmacists, peer workers, and others. Public settings were the most common contexts in which respondents worked. So that included hospitals, community health services, or the public health system. And then the second most common context was the community or not-for-profit sector. So we asked participants, started with a very broad question. We asked them to recall if any of their patients or clients living with a communicable condition had experienced legal problems or disputes in the previous 5 years. 87% of those who responded to this question replied that they had. We then asked them to answer what percentage of their total patient or client group they knew to have experienced legal problems or disputes in the past 5 years. So of their total patients, how many of them they think had. Those results actually varied really wildly. We had one respondent saying it was just about 5% of their patient or client group, and then another who reported as high as 90%. So what do those legal needs look like? Participants were asked to select from a predetermined list of legal domains in which their patients or clients experienced a legal problem or dispute in the previous 5 years. So the total list, which includes about 20 different domains, was taken from a 2012 large-scale national legal needs study undertaken by Australian governments and legal services providers. So the number one domain by quite a long way, as you can see in the table there, is migration, which tracks with the data that Reece just presented about the services help provides. Housing was the next one, and you can see some of the specifics in that table there. Money and debt, then health, including long-term injury and illness, complaints about health services, and then crime. So being charged, arrested, questioned, or jailed in relation to a crime. So those were the 5 most common categories. So what are the impact of those unmet legal needs? Participants were also asked to rank the areas of unmet legal needs that their own clients or patients experienced in terms of the relative impact of each legal need area. So the last table was a count of just what those needs had been across their clients, and this is about the impact on health and service delivery. So the ranking resulted in the following list. So in order from most to least severe. Whoops, going back. So you can see there, number 1 was being a victim of crime, robbery, theft, vandalism, threatened or actual assault. The second, family law, covers a wide range of issues, disputes over wills, custody issues, child support, and domestic violence. Discrimination was the next one. We also saw that in the HALC data. Health or long-term injury, so complaints about health services, problems with access to or quality of health services, medications or payments. And then the 5th, in terms of impact on health outcomes and service delivery, were insurance disputes, which Reece discussed as well. So hopefully you'll be able to see this table okay. So as well as, I guess more broadly, as well as looking at the impact on individual patients' health, we asked about the impact on public health, the respondents' own ability to provide health and other services, and broadly the effective functioning of the health system. So I think, as you can see in that table, the most notable finding here in the first row is that all respondents noted that a legal problem or dispute has either a severe or moderate impact on the individual health of a person living with a communicable condition. So given that the workforce is already providing a support, as we know in lots of cases, in terms of their patients and clients' legal needs, what does that support actually look like? So we asked if our participants had ever been approached to provide support to their patients or clients in relation to a legal issue or dispute, for example, as an expert witness in formal court proceedings, or by providing a letter regarding the patient's treatment for the purposes of a legal dispute or process, such as a migration claim. So 76% said that they had been directly approached for support, and then 24% hadn't. Of those who had been directly approached, 57% of requests for assistance came directly from the patient or client, while 30% came from the patient's legal representative, and then the rest from colleagues, insurance companies, or social workers. As for referrals, we can see that there are already connections between the workforce and legal services. 84% of respondents had made a referral for a patient or client to a lawyer or legal aid service in the previous 5 years. So despite the fact that respondents wanted to support their patients and clients, and in most cases were already engaged in that support or referral to services, for those experiencing legal need, respondents were not confident in their skills in this area of practice. So no respondent said that they strongly agreed that they were confident in screening for legal problems. 61% said they somewhat agreed that they were confident in making referrals to legal advisors and services, and that they knew where to get information and advice about resolving legal problems. 65% stated that they somewhat or strongly agreed with being concerned about providing general information to clients. They worried that it might be construed as legal advice. 52% of participants agreed they would like to make more referrals to legal services and support. We also asked participants to consider the use of a simple legal needs screening tool to support patient and client referrals to legal advice and services. So what we mean by that is something like a short questionnaire that could be used with the patient or client to identify potential areas of legal need. And maybe unsurprisingly, 95% agreed that a simple legal needs screening tools to support referral to legal advisors and services would be useful in the Australian context. So what does all of this tell us about how we can better educate the BBV and STI workforce around these issues? So as I said, despite the active efforts of the workforce to engage and provide support for patients or clients with unmet legal needs, respondents weren't confident in their ability to do so, and they wanted further education, training, and practical support to better aid their patients. All respondents agreed that it would be useful to have additional education about communicable conditions in the law, particularly how to screen and provide effective referrals and support. In terms of the areas they were specifically interested in further education about, there were quite a broad range. Migration and healthcare was, again, as we're seeing this pattern across the data, a significant focus, including how to support patients or clients through their migration process, and also about migration-related employment and discrimination issues. There was also a strong interest in transgender-related law and rights. Participants also wanted kind of regular updates on a range of legal issues or practices as they are changing, important to assisting them in their clinical or support practice. So the kinds of regular updates included changes to the law, confidentiality and the consequences of breaches, as well as information about insurance and disclosure. There was also a strong interest in culturally and linguistically appropriate information about laws and rights relevant to culturally and linguistically diverse patients and clients. So a few key takeaways here. I think it's important, as I said at the top, to say that the results reported here are some of the only data that we have on the legal needs of those living with STIs or BBVs in Australia today. They form a really important view of the incidence of unmet legal needs and the significance that legal issues have for those living with a communicable condition. So this appears to be true across a range of areas, both their personal health, but public health more broadly, and the ability for the STI and BBV workforce to sustainably provide services like testing and treatment to those facing unmet legal needs. So the picture we got from these results overall is that the workforce believes that legal issues faced by their patients and clients does have an impact on health outcomes. It's also clear that the BBV and STI workforce plays a key role in understanding and supporting patients and clients with unmet legal needs. And significantly, that's through both referrals to legal services and with direct support in legal proceedings. Finally, as I've spoken about, there is a strong desire from the workforce for further education in this area. And I think that means a need to build stronger partnerships between the BBV STI workforce and legal services with specialist expertise. Thank you.
Well, thank you, Ben. Thank you very much for that. While Carrie and Erin pop on their videos and we begin our chat, I want to thank just now Ben and Reese for presenting that work. That was fantastic. It was complicated work you presented, written by a whole number of us, and I think that was really fantastic. We've got some questions coming through already. Please do set up, so please do start thinking about your questions and send them through and we'll ask them as we go. This next section is about 20 minutes or so where we're going to kind of start to flesh out some of these issues and hear some more experts. Everyone in green, as you can see, I seem to not get that memo. But again, I welcome Erin and Carrie here to talk about some of the results that have come up so far. And look, this is just a kind of trying to take it to the policy level and a bit of a national level with both. So thanks for joining us. I'm going to start with Erin, just because you're on my right here. We heard a lot of information there from Reese and then from Ben. You know, first impressions, what stands out for you as someone working particularly in the HIV end of this spectrum?
So I think the first positive lesson I'm going to take from that is that on one level, the rise in demand for health services is really encouraging, because you only discover legal barriers to achieving certain goals if you're trying to achieve that goal. So I'm encouraged by more HIV positive people seeking to immigrate to Australia with their partners and seeking careers in sectors that they couldn't previously access. And I'm also encouraged by the decline in early access to super, because that speaks to a modern reality in which you don't need that so much anymore. But I think the difference, as Reese was talking about there, the difference in the HALP cohort to the general cohort, so HALP's cohort being younger, more heterosexual, more female and more overseas born, sort of suggests that some people are in more need of legal services than others. So some people are doing better than others, not from a health perspective, but from a legal perspective. Immigration is obviously the standout issue, and there's issues related to that because that's a particularly vulnerable cohort, often no access to Medicare, often not enough resources to engage with legal services, often English as a second language. So that's a particular vulnerability for that cohort. From what Ben was saying, legal issues are emerging in healthcare settings, and so there's an obvious need for workforce education there. And some of those issues that are emerging are issues that everyone's going to face, but HIV is going to complicate that considerably for that cohort. And I think that's reflected in some of Ben's comments there about having a severe effect on the health of the individual. So in one way, I'm kind of frustrated by the fact that in order to do many of the things that HIV negative people take for granted, HIV positive people are going to need a legal advocate. And in particular, I'm quite frustrated about our immigration system that seems to be so discriminatory and out of date. So I think the lessons I would draw from that are legal representation, improving access to legal representation is going to be important in the future. Workforce education is clearly going to be important in the future. And hopefully, if we are successful in the policy space, then reducing the need for legal representation as well as the other elements of that three-pronged approach through legislative reform would be good as well.
Yeah, thanks, Aaron. Carrie, same question, I suppose. What jumps out to you? Obviously, viral hepatitis focus for you. What are you hearing when you hear that information?
I would echo a lot of what Aaron just said, and I guess building on that, there was a few things I was really struck by in the presentations. One was about how critically important other sources of evidence are, of community-owned and community-driven data sources, and how they present a much broader picture of what's happening. And sometimes when we rely too much on narrow epidemiological monitoring and surveillance data, it doesn't give us the full picture of the people and their needs and how diverse they are. And I think there's lots of opportunities for us to strengthen different community-owned and driven data sources. I guess the other was how stark that was Ben presenting about zero confidence in screening for legal problems. That's a pretty full-on kind of number, but also that 95% then are looking for a screening tool. So that just seems like such a wonderful opportunity to go into that space. But I guess also some of the complexity of unpicking where people might be inadvertently doing legal work to kind of fill the gaps, I guess, to your point, Erin, about us needing more capacity for people to engage with appropriate legal supports and to be able to identify and then appropriately refer on for action by trained legal people, which I'm not one.
Thank you, Carrie. Yeah, look, there's some really interesting moments. I mean, I think something that struck me was we're doing it, we want to do it better, we're not confident, but please give us some tools. Couldn't get a better picture, really. I mean, that's something fantastic to work with. You know, I'm a trained legal person, indeed, Erin is too. You know, and it's complicated. You know, screening people for issues takes a lot of training and a lot of skill, and so we need to obviously get those supports in place. I'm looking forward to doing that. Erin, I mean, you mentioned, I think, just reflecting on your comment there about the change over time, you know, you mentioned early access to superannuation's changing, emergency wills maybe are changing. Reece made a comment there about formal criminal matters not being a huge part of HALC's work. We often talk about criminalisation as a broader concept, not just formal criminal law, but where criminal law kind of hides in places like the Public Health Acts and other places. What does that look like today? If it's not something that kind of hits a lot of people, at least at HALC, still an issue, I assume, but what's it looking like? What's changed?
Yeah, so I think criminal cases are always going to happen to few people. So out of the and indeed, with a rise in people seeking legal support for other things like immigration, then the proportion might fall slightly. But the criminalisation of HIV is nevertheless, even though it happens to few people, incredibly important. And I would say that's because of four things. It's because when criminalisation happens, it happens to the most vulnerable in our community. So poorer, non-white, trans people, perhaps sex workers, LGBTIQ people, it happens to them. And secondly, when that happens, it affects everybody, not just those people, because the way that the media covers criminalisation stigmatises people with HIV, it constructs them as a threat to everyone. That undermines our efforts to try to destigmatise HIV, and it also means that the next criminal case that goes before the courts is likely to get treated even more harshly. So there's a weird feedback loop that happens between media coverage and the courts, which ratchets up severity of punishments. And that also serves as a constant reminder to all people with HIV in Australia that they're vulnerable to state surveillance, policing and control. And that undermines quality of life for all positive people. And thirdly, the way that the laws are structured in some states, including in New South Wales, makes it specifically and only the HIV positive person's responsibility to prevent HIV transmissions. And that means that all positive people are always vulnerable to an accusation that they didn't take reasonable precautions. And when that happens, even when there's been no HIV transmission, we've seen the courts and the police respond disproportionately harshly by denying bail, by detaining people pending trial. So people can lose jobs and have their lives ruined all because of an untested allegation. And finally, because we're currently seeing this legislative backsliding across multiple jurisdictions in Australia, where mandatory disease testing laws, for example, do nothing to prevent HIV transmission or to improve the health of people with HIV or to secure the health of police officers or other emergency personnel. But they do stigmatise HIV and they do contribute to a disabling environment, and they continue to expand from police to prison guards and beyond. And consent laws is the most recent example, which is in New South Wales and possibly in other jurisdictions as well. And that's recriminalised even after we finally got rid of the need to disclose your status before sex. It's recriminalised misrepresentations about HIV status and also gender misrepresentations as well. And so that absolves HIV negative people from any responsibility to manage their own sexual health, and it puts all the responsibility back onto HIV positive people. I would argue that that makes HIV transmission more likely, not less, because relying on other people to manage your sexual health is notoriously a very ineffective strategy. So the point I'm trying to make there is that criminalisation is a major barrier to ending HIV transmission and to achieving good quality of life for positive people. And so even though we see it in relatively few cases, it has a disproportionate impact on the individual and all positive people in Australia, and then the broader society as well.
Thanks, Aaron. I mean, beautifully put. I love a well-structured answer like that. Thank you. But so right, this remains, you know, a priority and a battle, and becomes more complicated indeed over time. Little surprises emerge. Carrie, I mean, you might have something to say about that too, but your comment about community-controlled and owned data sources really struck me. You know, we have, I think, a pretty reasonable sense in some ways of a historical, you know, kind of picture of legal needs for people living with HIV. Viral Hep, not so much is my sense. I'm sure there's continuities, I'm sure there's discontinuities, and we'll address those maybe in my next questions. But yeah, what do we know and what do we need to know, particularly about viral Hep and people's experience with law?
Yeah, I guess the first is to separate viral Hep into hepatitis B and hepatitis C, because they're two quite distinct diseases with different communities affected, different treatments, different, a whole range of things are different about it. There's lots of commonalities, of course. You know, for example, they're both leading causes of liver cancer, and there's lots of crossovers, for example, with HIV, to Aaron's comments about the completely unnecessary so-called spitting laws, or a kind of case in point there. And we definitely know a bit more about hepatitis C and legal issues, and a lot of that relates to people who inject drugs. If we look at our kind of stigma report data that comes out, that tells us that that group in the community is the most stigmatized group we've got. And I just want to acknowledge Avel, who's here as a fellow national peak of ours in the meeting today. And also Aaron's point about the different ways in which laws are, particularly drug laws, are applied to different groups in the community, and where we see police surveillance, but also where we see hyper incarceration. And I think that's a key kind of point about hepatitis C. Is earlier this month I had the privilege of giving a keynote at the Viral Hepatitis Conference, and one of the comments that I made in that was that hepatitis C transmission is going to become a disease of people who are incarcerated, and that these are the spaces where transmissions will occur. And, you know, building on Aaron's point about putting pressure on the individual rather than having structural solutions, the reason for that is because of the profound failure of the prison system to put in place effective prevention and harm reduction measures, which means that's why transmission is occurring, is because people aren't given the opportunities to do preventative measures. And also at that forum, I guess, this is potentially an example of where we need better partnerships between the health and the legal sector, where, you know, maybe this work needs to be led by the legal sector for action about this pretty profound human rights issue where people have this care in the community, but they do not have it in prisons. And perhaps there's some fabulous legal people in the meeting today who might be interested in bringing together some type of class action, because it's profoundly serious in that space. So I think we've got legal issues that relate to the individual, and then ones that relate to the systems and opportunities for action across both of those.
Thanks, Carrie. And if there is anyone who wants to fund a class action or similar, please write to me or Carrie. We'll happily pass on your details. You never know. There's a lot of great, criminal law people and people who want to get rid of prisons, and we hope they get on board with this. I think this is a really important story. Carrie, your point about thinking about viral hepatitis, not together, but hepatitis B and hepatitis C, various communities within that. Aaron, HIV, another BBV. Similarities and differences seems to be a bit of a theme here. You mentioned the spitting laws. Maybe I'll start with Aaron and then I'll go to you, Carrie, and just jump in. What is shared and what really might be different between these BVV areas, in relation to law?
So there's, in terms of similarities, I think there's a lot of intersectional stigma, to Carrie's point. So both hepatitis and HIV are affecting mostly marginalised communities. And I think one of the obvious things that will jump out there is that judgment discrimination in healthcare settings is going to be an obvious similarity across both areas. In many situations, hepatitis and HIV are both subject to the same laws. So Carrie mentioned mandatory disease testing laws just now, but the New South Wales Public Health Act puts a duty on a person with a notifiable or scheduled condition to take reasonable precautions against transmission. And so that means that as we moved away from HIV-specific laws and we made those laws broader, so I'm talking about notifiable, scheduled, BBV, STI, so broad categorizations, we potentially criminalised a much greater cohort, including people with hepatitis. And we haven't seen prosecutions for conditions yet other than HIV, but it is a constant worry that I have that that could be in our future. And so I think that points to a need for us to pursue legal education so that people can stay within the rules and know what to do if they come into contact with police and the courts. But it also points to a need for advocacy and training for legal professionals, not so much about how to defend these cases, although that would be great, but rather an attempt to move the legal and coercive systems off that path to a more enabling environment.
Yeah, great. I mean, before I throw to Carrie on that, thank you for picking up a real, a point that I love to make, which is, some great positive movement there around from HIV specific laws. But then, we created New South Wales with the reasonable precautions offence within the Public Health Act, one of our only endangerment offences known to criminal law. We don't have endangerment offences in New South Wales really for anything, but we do in relation to people living with communicable conditions that are listed, so no transmission needs to have occurred, merely the risk thereof, and it's a very serious criminal offence for that reason. Absolutely. Carrie, over to you. Similarities, differences, what can we share, what can't we share?
I guess one of my reflections on Reese's presentation as well is about that things are constantly changing and evolving, and I guess in the legal space, but also in the health space. So I guess before I turn to hepatitis B, I'm just reflecting on the profound changes that have happened in hepatitis C over the last 5 years with the cure coming on board, and 50% of people estimated to have hepatitis C receiving the cure. And so the population has changed a lot and the needs have changed, but also we've had emergent legal issues about post-cure. And there's some really fantastic work coming out of La Trobe from Kate Sear and co out of that, and I've had the privilege of being part of their advisory board on that work. But there's really interesting stuff that relate to both health, that one need to still continue to care for people, and that just because in the epi the numbers might disappear doesn't mean the people do. Because they remain having a whole series of both health and legal issues, including risk of liver cancer, but also emergent legal issues such as social security and insurance. So that I think that's a kind of thing that we have in common. So we have to be active, I think, in this space, and I think constantly talking to communities to understand what the emergent kind of legal needs are and how we can be responsive to those.
Fantastic, Carrie. I agree. What a great line. Just because the epi goes down, the people are still there. I think that's a fantastic one to remember. I might get Reese and Ben to turn on their videos and we'll spotlight them while I just ask a final wrap up to Erin and Carrie in this little segment. Just to tic-tac continually, Erin, I'll go back to you there. Couple of leading edge issues. We've obviously spoken about criminalisation, remains important, but particularly thinking about us formulating the next national strategy, both in relation to hepatitis B and C, and indeed about HIV. Connections, what's in your mind, what's in the community's mind around law as we start to think about that?
So there's a constant narrative about what new and improved technologies like better treatments or a functional cure might mean for the law. And specifically, that's mostly in relation to reckless transmission of HIV, for example. But the idea there is that if HIV is destigmatized and normalized and treatable, then we would see fewer prosecutions or no prosecutions. But in my opinion, that's entirely too optimistic, because every time we succeed in securing some legal reform to make prosecution of positive people harder, the law adapts and finds new ways of being able to prosecute that cohort. So on the one hand, we're seeing new technologies like U equals U and PrEP in the health space reduce the incidence of disclosure and also the need for disclosure. And indeed, the legal need to disclose before sex in New South Wales was removed back in 2015 or 2016, I think, from memory. But on the other hand, we're seeing the law recriminalise positive people in really concerning ways. So New South Wales just recriminalised misrepresentations of HIV status. And that creates an incongruence between science and the law. And more what we're seeing is the law is moving in a direction which is unsupported by science or by evidence. And that's really concerning. So the short answer is that the enabling legal environment, really important, and arguably more important now than it's ever been. We spoke for many years about low-hanging fruit, but we're well beyond that now. We're down to 600 new transmissions a year, roughly, and as we get closer to zero transmissions, preventing each new transmission gets harder and it gets more expensive. So if we're going to have a chance at ending HIV transmissions and improving quality of life for positive people, we now have to do the hard stuff that's been resistant to change for 30 years. It's not going to be enough to just get the health promotion right. We're going to need a legal environment that destigmatizes and normalizes HIV and allows people to talk openly about HIV without fear that they're going to be prosecuted as they negotiate HIV prevention as part of their sex lives. And so that hard stuff includes immigration reform, includes the enabling legal environment. And so in the current national HIV strategy, I think the wording is something like to monitor laws and policies which impact on health seeking behaviour and ameliorate legal, regulatory and policy barriers to something or other. And so that's in the 8th national strategy. The next 9th national strategy is currently being drafted. And so we're going to try to build on that, monitor and respond to laws and sentiment in the 9th national strategy and see if we can expand that to start tackling exactly what it is that we want the legally enabling environment to look like.
Thanks, Aaron. A beautiful quotation from memory from the strategy, your full marks. Carrie, you don't need to quote from your strategies, it's okay. But apart from ending hepatitis by 2030, what's on the agenda in the next set of this next strategic period for viral hepatitis for you and the law? What are the conversations you're having? What do you want to see there?
So I think hepatitis B is a major area that's been underdone in a whole range of ways. The communities haven't been had the resources to be activated sufficiently. There's not enough community workforce. There's a huge amount of legal needs that relate to hepatitis B. We know about some of them. We know there's lots of need, but we don't quite know enough about it. And migration is inherently linked with hepatitis B because we've had strong preventative kind of measures in place for, I guess, with vaccine for the last 20 years or so. So I think hepatitis B is a really, really critical area. And I guess building off of Aaron's comments about the national strategies, for the Hep B and the Hep C strategy, it's the fourth goal about we've got the words eliminate the negative impact of legal and human rights issues in both of those strategies. And that's a big ask, that's a big goal, but we don't have any way of measuring that. So a couple of weeks ago, there were some really fantastic workshops that were held to talk about the targets related to the upcoming refresh of the national strategies. And it was identified that it would be really valuable to have some type of legal target within that. And I know one of the things that came out, I think last year, was the new BBV and STI research strategy. And legal issues in hepatitis B as an opportunity to be progressed through resourcing through that strategy, I think is really critically important, because we do need a way to measure and we do need a way to talk to communities within that. So I think the other is about people ineligible for Medicare is a really, really critical issue in the hepatitis space. But I think also strengthening partnerships with the legal sector. So I think they're not named enough within the strategies that maybe have a kind of lens that need to be broadened beyond a kind of testing, treatment, kind of narrow public health intervention lens to a broader whole person, whole life course lens. Some thoughts?
Thank you, Carrie. Yes, another good quotation from the strategy, really eliminating this time. So maybe that's something that our colleagues in HIV can also adapt, eliminating those legal barriers. Thank you to Erin and Carrie for that. That was a fantastic way of sort of taking this massive data and bringing it up to kind of a strategic and national level. I appreciate it. I'll keep you both there on the screen. Feel free to jump in. We're just going to turn to Reese and Ben now for a few questions, but I'm sure both of you might have something to add as well. Please do keep sending in those questions, and I'm going to summarise them and feed them back. I see that Ben and Reese have been answering some online already by typing. Reese, I'm going to ask you the first one, but before I do, a wonderful legal colleague, Sean Mulcahy, has asked if the reports are available. Look, they are available, but if you just want to email me, Sean, or anyone else, and we can share that with you in those early drafts, if that's useful. And indeed, if there are any follow-up questions about the data, please do feel free to email me at UTS, and I'll get you that information. Reese, you answered one of these questions a little bit, I think, online, but just for everyone's benefit, wills and estates, if I remember correctly, you said, look, wills and estates are still with us, but they've changed. The nature of them have changed. Just a brief comment about how that has happened. The question really highlighted the fact that it's a really, even though emergency wills and this kind of work, bedside wills, I know was a big part of HALC's work for a long period actually, has gone away as we understand it. It still seems to represent a pretty reasonable part of your work. Little comment there about what you're doing.
Yeah, correct. So that's, and as Erin pointed out, that has definitely decreased, but people are still coming to HALC for end of life planning and drafting of those types of documents, as well as probate issues. And the reason for this, I mean, it could be potentially the fact that we are just known for the fact that we do that work, and therefore it's just word of mouth. But I also think there's some specific considerations, such as the fact that when you're planning these documents, you might be kind of disclosing some health conditions or things like that. So you might want to feel comfortable in disclosing those conditions, and therefore you want a legal centre that does specialise in dealing with those types of matters. And especially there's some important considerations around drafting, say, wills. If you're choosing, say you've had a breakdown because of a disclosure of your status, something like that, a breakdown of relationship, there might be some considerations you need to take into consideration for when you are drafting that document. So yeah. Thank
you, Reese. Appreciate it. So specialism indeed, and reputation, even in the community legal setting. That's fantastic. Ben, one for you. You mentioned that the legal needs of people, particularly unmet legal needs, have a range of impacts: personal health, ability to continue to offer health services, and indeed public health and health system impacts. The question really is that it seems obvious around how a legal issue might cause stress for someone and so have an impact on their individual health. But can you talk a little bit more about your theory about how it impacts on the ability of clinicians to offer services, and indeed the public health or health system impacts?
Yeah, I might just also broadly make a comment, I think, about the commonalities between HIV, Hep B and Hep C. I think it's important to keep in mind. I think one of the things there is that stigma associated with all blood-borne viruses is is weaponized in legal senses, not only against people living with and affected by BBVs, but other populations as well. So the recent mandatory disease testing laws are brought in New South Wales. There's an expectation, I think, from all of the people, many of whom are on this in the audience and presenting in this, is that the main people these laws are probably going to be used against are homeless people, First Nations people, a lot of not only people who are living with and affected by BBVs. And I think thinking about that policy, that legal environment more broadly, and having solidarity with those groups will be a really important way of making progress on some of those issues. So I just wanted to make that broad comment. In terms of impact of these things on the public health system more broadly, I think that's a very difficult question to answer. I suppose it certainly most obviously makes it harder for health workers and support workers to do their jobs. We know that something that we come across at ASHM again and again and again when we talk to clinicians who are supporting their patients and clients is that they really, really care about this. They really, really want to be helping their patients and making their lives better. So I think that the clinicians who are supporting their patients with BBVs are already thinking about the health of their patients in a really holistic way, and see these legal issues as part of that broader picture of their patients' health. So I think that's framed within how they are already thinking about them. I mean, we could imagine, I suppose, extrapolating up to how that might affect the response, the BBV and STI response in Australia more broadly. But I think at an individual level, that's certainly the case.
Thank you, Ben. Reese, one for you. Indeed, a question, and I'll just read it out. It's beautifully written. So broadly, Reese, what are the primary kinds of immigration law issues that help clients face? For example, is it migration streams or visa classes or access to work, welfare, health services, or are there a whole bunch of other issues that fall outside that list?
All of the above. So if we look at the kind of the migration pathways, I think if we look at it more from that beginning strategic planning aspect to it. So the fact that there are just very limited streams, so, you know, protection visa, partner visa, or sponsored visas, so working visas, sponsors, you've got to be thinking about what the next 5 years of your life is going to look like at that initial stage. And that also means, you know, especially if you've got like an employer sponsored visa, making sure that although you don't have to disclose your status to your employer throughout that process, engaging with the right kind of legal services during that point to make sure that doesn't happen is really important. And then all of those kinds of considerations about Medicare as well, and access to Medicare is kind of hindering potentially people's access to not only HIV treatment, but other like mental health services, especially. Like I said, this is a 6-year-long process potentially for people, a 9-year-long process if you go even further to the court. And I mean, just that impact alone, not even taking into consideration the other factors, is huge, and is something that we really need to consider about what impact that is having on our clients.
Thanks, Reese.
David.
Oh, sorry, Aaron, yes?
I wonder if I can just jump in there.
Yeah,
I think I'm very frustrated by, like, one of the things that I think we're seeing with this rise in demand for immigration support services through HALP is just the fact that Australia's immigration system is really out of date, very discriminatory. And so as people are just trying to go about a normal, healthy life with HIV and immigrate to other countries with their partners, they're running into Australia's immigration system, which is a problem. So I think immigration reform is definitely on our agenda as we go forward. But just to give some context to that, positive people bring to Australia skills that we need. They pay taxes. Modern HIV medicine means that they don't cost very much more than your average Australian, really at all. And some of the older off-patent medications are now very, very cheap. And on top of that, there is this fear in Australia that an HIV diagnosis, so if you're here on a temporary visa, and a diagnosis in Australia is going to mean that people know that it's going to complicate immigration processes or that you might get kicked out of Australia. So there's a reluctance to know if you have HIV. There's a disincentive to test. And what that does internally is makes it really hard to eliminate HIV domestically. So I would argue that if we got rid of HIV as a factor at all in immigration, so immigration would turn on the usual things that immigration turns on, and HIV was not a part of this, that would save Australia millions. And it undermines that argument, the idea that we can't afford for HIV positive people to come to Australia because there'll be tourism for our health services. It's just not buoyed up. It's just not shown by the evidence of countries like the UK, for example, where HIV is not part of their immigration process. So that really is the goal. So we've got to remove HIV from our immigration services, from our immigration process, if we want to eliminate HIV in Australia, and also if we want to help people who aren't Australian citizens or residents already.
Thanks, Aaron. I agree. And before I throw to Carrie, because she was nodding fiercely in relation to Reese's point about the impact of migration on lived lives. In our interviews we've been doing so far with people living with HIV and hepatitis B, repeatedly, unprompted, our interview participants say things like, "It would have just been better if I was never diagnosed, because all of a sudden that caused all of these issues." And then we hear what the issues are and the kind of pathogenic, I suppose, nature of our migration system and the pathogenic nature of borders, which is something we're thinking about a lot. And exactly as you say, it is, from the horse's mouth, so to speak. This is not theoretical. This is exactly the experience of people. Carrie, obviously migration, as you said, and hepatitis B have a link. You were nodding fiercely at Reese's comment about the impact it has on people's lives. A comment there I felt was needed.
Yeah, there's a lot to this, and some of it's about communities hiding and people in communities not willing to come forward and becoming really, really unwell. Untreated hepatitis B it can be really serious. We want people engaged in liver monitoring. We want people engaged in care. We want people to feel safe. And these are often, hepatitis B it's an intergenerational, it's a family disease. It's highly complex about how it's understood by different groups, how it's described, the meaning that's attributed to it. And these things really need to be, I think, facilitated with people, which is why the communities being resourced to engage and work through these issues is so critical. And I guess one of the key gaps that have been identified in multiple areas in hepatitis B is the lack of a community workforce. There's essentially no funded community peers or workers across the entire country. So every time we talk about this is exactly the type of thing where if we had activated, resourced communities to be able to work through these issues together, they would be able to help facilitate this to get both good health outcomes and good legal outcomes.
Carrie, I've got a comment I'm going to read out from the wonderful Kate Sear, which is in response to something you said, Ben, and I'll make a comment on it as well, which is Kate says, just a comment building on Benjamin's comments on the weaponization of stigma. I think it's also important to acknowledge that there are strategic advantages or incentives on occasion for depicting those who live with BBVs in ways that might be stigmatizing. So it's not necessarily or only just an external process imposed on people who live with BBVs, but something their lawyers might actually do in support of them through legal advocacy, including in consultation with the client themselves. Kate says that she and colleagues are writing about this on their project on Hep C and post-cure lives, and we'll have some further publications to share soon. So encourages everyone to get in touch. I'm making that on her behalf, but please do. It's something that I think, though, a perfectly good point, but an important one, which is law. The terrain of law is tough because, particularly in relation to my specialty in criminal law, but in relation to others too, stigma is something that social stigma is extremely damaging and bad, but is also something that we as lawyers and the legal system in fact creates and uses sometimes to the advantage of people living with BBVs. It's carefully handled, I should say, but if someone is discriminating against someone living with hepatitis B, hepatitis C, or HIV, and we're able to publicly shame and discriminate them for that, publicly shame and stigmatize them for that, that can be obviously to the advantage of that client. Law is a funny world like that for those reasons. I'll leave that as a comment unless Ben wants to respond in particular, but I think that's something we need to keep in mind, which is this double-edged sword of law. Sometimes we use it productively, indeed, but must be handled with great care. A final question to Ben, and then we might wrap up, which is just a comment about insurance claims. And Reese may well have something to add to this too, I think. I know that Health is working on some insurance matters at present. One person writes astutely that insurance claims and the time spent on them, it came up both in the health figures as well as something of concern to the clinical workforce through the survey that Ben addressed. This perhaps indicates another area of persistent discrimination, that is in relation to insurance. Any comment? Is it likely to continue? How should we respond to this commonality between insurance and the difficulty of claiming and the change over time. I'll start with Ben, and then Reece, you might have something to add, and indeed Carrie and Erin.
So this is absolutely one for Reece as a non-lawyer on the call.
Oh, well, there we go, Reece, all yours.
Yeah, so good question. So it definitely is something that we at HALC are seeing more frequently at the moment. And so the way that we are tackling this as lawyers is that we are challenging it going to, for example, the Anti-Discrimination New South Wales and claiming that they're not relying on reasonable statistical and actuarial data. So like I said before, we're quite confused as to how they're coming to this decision process because it varies depending on the insurer. And so what we're trying to get a hold of is the data that they're relying on, which is not easy to do because there's no kind of provisions within the Anti-Discrimination Act for us to get a hold of that information. So not until we progress to NCAT or further can we actually compel insurers to provide that information. And often we won't progress that far because it might not be in the best interests of our client, because if they can settle during that process, then we might do so for that fact. So then we won't get a hold of that data. So it's a bit of a difficult balancing act at the moment in trying to determine kind of how we progress in this area. And we are constantly making submissions whenever there are reforms to discrimination acts around the country, that there needs to be some kind of provision that allows us to get a hold of this data so that we can make that assessment ourselves and not just rely on the insurers to make that assessment.
Thank you, Reece. Erin?
I would add, I'd add to that NAPA's been doing a little bit of work recently with a very passionate group. I think they're called the Inter-Insurance Group that they work for insurers, and they're keen to positively influence from the inside the way that insurance is assessed and people can apply for, etc. So they're doing some work around making what is required for positive people to get things like life insurance clearer, but then also they want to do some work inside the sector as well about figuring out how exactly they make assessments on how much it's going to cost or what the risk is that there'll be an adverse event, etc. So there's some positive work on the horizon, I think.
Thanks, Erin. As always, a wonderful point to end on, which is down in the deep weeds of actuarial tables and regulations. It's my favourite spot, but it is part of what we need to do. And I'm pleased that we have such fantastic people both here and in my team and indeed around the country who are doing that. That is very important work, if a bit thankless and detailed. It's super important. I want to just end before I say thank you to people who are speaking today, our guests, as well as those who are here. Please do get in contact with me at UTS, and I can pass on queries and questions to our panelists and indeed provide information about the project. You'll be hearing more from us over the next while, and we really encourage you to keep an eye out for any information about our research projects. We're just about to launch a poll if anyone wants to be added to our mailing list for those purposes. Please just hit yes, and we'll be able to get your email address through that process. But look, ending today's fantastic presentation, I want to thank first Reece Evans, obviously, for his presentation, and Ben Riley for his. They presented fantastically some really complex information that I know a large number of us have put together, and I thank you for that. It's wonderful to see our colleagues, as we say in universities in industry, doing that, but frankly, you did a better job than we could, and so I'm really thankful. And of course, to the fantastic Carrie and Erin, great colleagues, great friends, and fantastic thinkers and leaders in this space. Thank you for sharing your wisdom with us and your time. I know that everyone will have got all out of it. There's a bunch of questions we still haven't answered, which are directed to both of you, and I look forward to passing those on. So thank you, everyone, for being with us. Please feel free to log off now. Thank you again for spending time with us today, and we'll be with you soon with more information about the law, BBVs, and people having a great quality of life. Thanks very much.
Thank you.